Part 3. Children in Care. 46. In this part, lawful guardian means any person appointed according to law or by deed or will or the order of a court, to be the guardian of a child, or to have the custody and maintenance of a child. License means a license granted under this part. Licensed home means a children's home licensed under this part. Licensee means the holder of a license under this part. 47. 1. No person shall establish or maintain a children's home, hereinafter in this part referred to as a home, except under a valid license granted to him by the minister in respect of the home, provided that nothing in this subsection shall apply to a juvenile correctional center, b. any school, other than a school required by the minister to be licensed, c. any house where 4 or more children are boarded and maintained by relatives of such children, or by the wish or with the consent of the parents or lawful guardians of such children, save in cases where the minister, by notice in writing, expressly requires any such house to be licensed. D. Any home or orphanage maintained wholly by the government. 2. Save with the prior written permission of the minister, no person shall maintain a home at any address or location other than that provided for in the license granted in respect of the home. 3. A license shall be valid for a period of 3 years from the date of its issue and may be renewed successively. 4. Save with the prior written permission of the minister, no license shall be transferred into the name of any person other than the licensee. 48. Every person who desires to establish and maintain a home shall make application to the minister, in the prescribed form and manner, for a license. 49. 1. The minister, in his discretion, may refuse to grant a license in respect of any home, or may refuse to permit the transfer of a license or to renew a license. 2. The minister, in granting a license, may attach thereto such terms and conditions as he may, in any case, think fit. 3. Where, in connection with any licensed home, the minister is of opinion that there has been any contravention of any of the provisions of this act or of the terms and conditions of any license, the minister may cancel any license issued in respect of such home, or may suspend the license for such period as he thinks fit, and may apply to the court under section 57 for an order or an interim order for the removal of any child from the home. 51. An appeal shall lie to a judge in chambers against a. Any refusal of the minister to grant, permit the transfer or renew a license. b. Any term or condition imposed in a license. c. Any decision of the minister to suspend or cancel a license. d. Any decision of the minister under section 47, 1, c, requiring a school or house to be licensed. 2. Every appeal under this section shall be lodged within 14 days of the date on which the aggrieved party is notified of the refusal or decision of, or the terms or conditions imposed by, the minister, and the procedure on such appeal shall be in accordance with rules of court made for such purposes. 3. Where an appeal has been lodged under this section, the minister, pending the determination of the appeal, may apply to a resident magistrate under section 57 for an interim order for the removal of any child from the home to which the appeal relates. 51. It shall be the duty of every licensee to a. Act in the best interests of every child in his home. b. Ensure that every child in his home receives at all times careful and humane treatment and suitable education. And c. Ensure that all the provisions of this part and all the terms and conditions of the license and the directions of the minister are at all times complied with in respect of the home and every child maintained therein. 52. 1. A licensee shall notify the minister in writing of the name, sex, age and date of reception of every child who is received into his home, and every such notification shall be made within 48 hours after the reception of the child into the home, and shall contain such further particulars as may from time to time be prescribed. 2. The licensee shall, after such notification, supply the minister with all such particulars relating to any such child as the minister in any case may require. 53. 1. Save where a child is removed from a home under an order of a court, a licensee shall not permit any child to leave or to be removed or transferred from the licensee's home, without first giving the minister 7 days' notice in writing of such impending removal or transfer, and except in the case of a transfer to another licensed home, without first obtaining the written permission of the minister. 2. A licensee shall forthwith notify the minister if any child is absent for more than 24 hours from his home, without the permission of the licensee. 3. A licensee shall forthwith notify the minister of the death of any child maintained in his home, or of the removal therefrom of any such child. 4. A person who removes from a licensed home, without the written permission of the minister, any child received into that home, commits an offense. 54. At all reasonable times, a. Any person authorized by the minister, or b. An officer of the Jamaica Constabulary Force, not below the rank of deputy superintendent, may visit and inspect any home for the purpose of verifying that the home is licensed, ensuring that the home is properly administered, and that the children therein are receiving adequate care and attention. 55. Where any person empowered under the provisions of Section 54 to visit and inspect a home has been refused admission to a home or to any place where he has reason to believe that a. An unlicensed home is being maintained. b. There is any contravention of any of the provisions of this part, the terms or conditions of any license or any directions given by the minister thereunder, or c. Any child is being maltreated, neglected or illegally detained. He may apply to a justice of the peace who may issue a warrant authorizing the person, or any constable, to enter the home or place at any time of the day or night and, with such assistance and by such force as may be necessary, to carry out the visit and inspection. 56. 1. If the minister is satisfied that the management of any licensed home, or the accommodation provided for, or the treatment of, the children therein, is such as to endanger or to be likely to endanger their welfare, he may give, in writing to the licensee concerned, such general or special directions with respect to the matters aforesaid, or any of them, as he thinks expedient for the welfare of the children in the home. 2. A direction under this section, a. may be served on the licensee concerned by being delivered personally to him, or by being sent, by post or otherwise, in a letter addressed to him at the home, and b. may be varied by a subsequent direction, or may be withdrawn by the minister. 57. 1. Subsection 2. Shall apply in any case where the minister, a. in exercise of the powers conferred on him by Section 49, has cancelled or suspended a license or has refused to renew a license, or b. has reasonable grounds for believing that I. any home is maintained in contravention of any of the provisions of this part, any of the terms and conditions of a license or of any direction given by the minister thereunder, or 2. that any child is being maltreated, neglected or illegally detained in any home. 2. Any person authorized by the minister in that behalf may apply to a resident magistrate for an order, a. directing the minister to remove any child from such home to a place of safety to be specified in the order, and b. making any necessary arrangements for the future of the child. 3. The court may make interim orders under this section upon application made by the minister under this Act. 4. An order for the removal of any child under this section shall operate as an authority to any constable or other person authorized to execute the order to enter any place at any time of the day or night and with such assistance and by such force as may be necessary to remove the child therefrom. 58. 1. A child who runs away from a person to whose care the child has been committed under this Act may a. be apprehended without warrant by a constable or an authorized person as defined by section 13(2) and brought back to that person if that person is willing to receive that child, and b. if that person is not so willing, be taken before a children's court which may make an order in respect of that child as if the child had been brought before the court in need of care and protection. 2. Any person who knowingly a. assists or induces a child to run away from a person to whose care the child has been committed, or b. harbors or conceals a child who has so run away and prevents that child from returning, commits an offense against this act. 59. 1. The minister may at any time order a child under the care of a fit person to be transferred to the care of some other person. 2. Upon a child being transferred in accordance with the provisions of subsection 1, the minister shall cause notice thereof to be sent to the person liable to make contributions in respect of the child transferred. 61. Subject to the provisions of this section, it shall be lawful for a child who is, by an order under this act, committed to the care of a fit person, to emigrate or be taken out of Jamaica with the written consent of the minister. 2. In giving his consent the minister may impose such terms and conditions as he may think fit. 3. The minister shall not give his consent unless he is satisfied that a. it would be in the best interests of the child, b. suitable arrangements have been made, or will be made for the child's reception and welfare in the country to which the child is going, c. the parents or guardian of the child have been consulted or such consultation is not practicable, and d. subject to subsection 4, the child consents. 4. Where the child is too young to form or express a proper opinion on the matter, the minister may consent to his emigrating, or being taken out of Jamaica, notwithstanding that the child is unable to consent thereto. 61. The minister may make rules not inconsistent with the provisions of this act or any regulations made thereunder, as to a. the manner in which children committed or transferred to the care of fit persons are to be dealt with, b. the duties and supervision of the persons to whose care they are committed or transferred, and c. the sums which may be payable out of the consolidated fund to such persons towards the maintenance and education of children committed or transferred to their care, and different sums may be specified for different cases or classes of case. 62. A child in a place of safety, children's home or in the care of a fit person shall have the following rights. a. To be fed, clothed and nurtured according to prescribed minimum standards and to be given the same quality of care as other children in the placement. b. To be consulted and, according to the child's abilities, to express his views about significant decisions affecting that child. c. To reasonable privacy, and to possession of the child's personal belongings. d. To be free from corporal punishment. e. To be informed of the standard of behavior expected by the caregivers and of the consequences of not meeting that standard. f. To receive medical and dental care, including psychological care, when required. g. To participate in social and recreational activities appropriate to the child's abilities and interests. h. To receive the religious instruction, and, as far as may be reasonably practicable, to participate in the religious activities of the child's choice. I. To be provided with an interpreter if language or disability is a barrier to consulting with the child on decisions affecting the child's custody or care. j. To privacy during discussions with a family member or a legal representative. k. To be informed about and to be assisted if the child so wishes, in contacting the children's advocate. l. To be informed of the child's rights under this act, and the procedures available for enforcing those rights.